Yes.
Lord, I am challenging an order of reversal of anticipatory bail granted to me, not upset by the High Court. I have 3 or 4 points to raise, Lord. The first is a point, Lord, that the judge had no roster to decide this case.
High Court.
The judge admits, Lord, that he didn't have a roster.
Hmm.
And I raised the question, Lord, before him, not that I raised it in appeal after having lost, and Lord, the lordships have held in a recent judgment, that if a judgment, Lord, is delivered by a court in breach of a roster, it's a nullity. Now, Lord, let me show you, Lord, what the roster was. 2 things, Lord, from the judgment itself, and then the actual roster. Kindly, Lord, turn to page 10. I'm surprised that the judge records this. He says, I have no roster, but I'll still decide. Below page 10, at the foot below. On behalf of the accused, opposite party, a further contention is taken that the state admits that the application, state is the opposite side, that the application was filed before a different court, and the matter
How it comes? Applications are not filed directly in any court.
No, but it's a matter of writing. It's filed in the registry. It's a matter of writing. You're not saying right. It's not filed before the judge.
It's not.
Correct. But what he means is this. Now, next week, the contention raised by the accused has substance, and the authorities referred substantiate the contention. Number 1. Now, second part, Lord, he says, if you not turn to page 15, 1.5. We'll come to merits later. 1.5. Lord, last about 8 lines. The accused could have taken a similar plea. About the plea, I will come later. Before a coordinate bench, which is having the roster for deciding cases under 438. That is, the accused has been granted. So forget the merits. So the judge says, I could have taken a same plea which I'm raising here before the concerned judge under 438. Now we will have a look at the roster. The judge admits not fairly that he had no roster. Kindly turn to page 88. Yeah. Your Lordship will find this is the roster of the judge who decided the matter. My Lord, the second line on the top, all bail applications under 439 corresponding so and so, excluding applications relating to PMLA, comma, all modifications, cancellation, relaxation of conditions of such bail. So all 439 bails, cancellation of bails and modification of bails, there is no jurisdiction of 438. Now, 438 belonging before the other judge whose roster is here. It wasn't filed. Kindly have a look at it. And that is why, with respect to the learned judge, recorded that he had no roster. Now have a look at this.
This is not part of the record.
It wasn't by mistake.
Three times it is adjourned already.
For some reason it was. Just have a look. It's a part of the cost list that I'm reading.
That's all right, but still.
I'll find it, but just have a look. From third number. Sheet. You have an opening sheet as the Lordship knows that. They said that you go to this roster. All right. Now, if this is so, now we will have a look at a judgment of this court on this issue. Then we'll come to the other issue. Kindly, my Lord, no, give a copy, please. Give a copy. 2025 SCC online SC 582. Your Lordship will find kindly turn, Milan, to paragraph 8 below.
Eight.
Now, paragraph 8 Lord, is a similar kind of discussion in regard to determination or the roster before the benches, etc. That is in para 8.
Right.
Now turn to 9. In the light of the law laid down by the High Court itself in Solar, as approved by a 3-judge bench in Prakash Chand, which has subsequently been approved by a constitution bench, as well as Rule so and so, we hold that any order which a bench comprising of 2 judges or a single judge may choose to make in a case that is not placed before them by the Chief Justice of the High Court or in accordance with Lordship's directions, such an order is without jurisdiction. In other words, an adjudication beyond allocation is void, and the adjudication has to be considered nullity. It needs to emphasize that the Chief Justice, being the primus inter pares, has vested the power and authority to set up the roster as bad, and such roster is final and binding on companion judges. Plainly, therefore, the order and the impugned order are without jurisdiction. Therefore, Lord, it was remanded back. That's the first point, Lord, which I wish to raise.
But
The second point.
how this matter was listed before this court?
I have no idea. And that is why we told the judge. Normally, people come to this court and then complain of something. I not complain right there. So, Lord, I think it should go back. This is not fair because it upsets Lord my liberty. More so. Not Lord a mere technical issue. It has grave and serious ramifications substantively on my case. Number two. Number two. Now, Lord, something very curious. The judge says that when you got anticipatory bail, the anticipatory bail, Milord, comes to an end when you go before the concerned judge to take Milord, formal bail. I haven't understood what the judge means. I'll show you. He says that a bail granted, anticipatory bail granted by any court, trial court, high court, supreme court, any court, when you actually appear, Milord, for a formal bond under 88, actually, your bail comes to an end, and the magistrate has a right to examine whether that you have not anticipatory bail, something which is startling. That's not the second legal error in the understanding of the judge. That Your Lordship will now find. Come straight to 15. That part, that para which I didn't read. Now, Milord, kindly turn to 15, the first subpara. The plea of the accused that this court is without any authority to adjudicate the case. That's the first point, which is on the issue relating to LCB. I hold that a criminal case within its ambit encompasses series of events and there may be change of circumstance. Anticipatory bail initially granted, and it is second provision. Anticipatory bail ends with either the accused being arrested or the bail being granted when the accused before the court. However, an order of anticipatory bail is never binding on the land magistrate. The magistrate is supposed to consider a change. There's no change here. And secondly, he can't consider anything. The accused could have, then the second part goes on without the first question. Then without last 4 lines. The accused has been granted bail by the ACM. Authority of the court deciding anticipatory has been exhausted. It will be for the court having jurisdiction to decide under 439, which is authority to deal such cases. Having considered that anticipatory bail terminated with the petitioner surrendering, I am of the opinion this court is the proper court to decide the issue. How? What is going on? Because this is completely wrong. The lordships have repeatedly held. Firstly, because there was a controversy in this court whether anticipatory bail would endure till the end of the trial or would it endure till framing of charge, etc. This court, Milord in Sushila Agarwal, has said that the anticipatory bail will endure till the end of the case, which is normal. But it can't be not end when I go for an 88 bond and say, Milord, I'm going to Milord, take a bond because I have an order.
Anticipatory granted by session to magistrate.
You had appeared before the court and submitted your bail bond.
Yes.
Yes.
I was released pursuant to
And I was released. That's a formal bond, Milord. Thirdly, my lord, only general observations made by a court in this order. My lord, your lordships have held that when anticipatory bail is granted, normally, my lord, it is a protective order unless there is something very, very gross. The court is not really sitting in appeal, my lord, again deciding the whole thing. Really speaking, the jurisprudence is one of cancellation if a man, my lord, abuses the role of anticipatory bail. Here it is granted, and after some time, my lord, the state comes and state is on caveat. There is something more that meets the eye. State is never on caveat on these small, without petty bail matters of a high ranking officer. So, my lord, you are fine. I don't know, my lord.
Anticipatory bail in 302 is very small thing. No?
And only on the
Your
ground,
lordship just see for
only on the
example.
ground that he is a government official.
No, I forget that. Lord, I'm not going by that. But just look at this. Lord, these stories, Lord, incredible. Story is that from my house, I am a public officer, block development officer, small office. Lord, the story is that there was a robbery in my house. And I came to know that some of those robbed articles were, Lord, sold in a particular shop, Lord, of jewelry in Calcutta. So I went, Lord, in my official car with red beacons and blue beacons, Lord, in broad daylight, and I kidnapped him in the presence of everybody. And then he's found dead. The completely incredible story, Lord. For small, Lord, jewelry, any other person will go and kidnap somebody in the middle of Calcutta and say, now I'll kill you. In an official guy, it's completely, Lord, there is something more between us. And Lord, this so-called cancellation, Lord, or an appeal, Lord, the respect, Lord, I don't think it is correct. That's my submission.
State.
Straight away, three things before your lordship look at anything else.
Ah.
I'll start with the third one first. A block development officer, I'll answer it in the route that I would want to follow. We'll start with the fact that a block development officer walks into a shop, CCTV footage available, placing him there, picks him up, takes two people. The other person is an injured eyewitness. His statement is recorded. There are other eyewitnesses whose statements are recorded, and this gentleman, under the camouflage of this fact that I'm a public servant, obtains this anticipatory bail on 25th of November. The order of anticipatory bail, curious as it is by itself, then says, I give you time of 2 weeks to go surrender. So I ask myself, the investigating agency has not arrested. Anticipatory bail clothes him with a right of being released until the time the investigating agency decides to arrest an individual or not. 3 days later, he goes before the learned magistrate, moves the bail application. The learned magistrate says, I am bound by the sessions judge's order, I grant you bail. So what has happened now is this, there is one order of anticipatory bail and there is a subsequent order of bail. I challenge as a state in a 302 anticipatory bail granted, affecting very critically my right to investigate the matter. I challenge this order before the Honorable High Court. The Honorable High Court notices that I have challenged both orders. The prayer, your lordships will find, is at page.
Let us see both the orders.
Please straight away. Please have first the order of the anticipatory bail, page 40.
For 2 minutes.
Yes.
Come back.
Page 44 is the order in anticipatory bail.
Yes.
Short order.
Hmm.
Application under 482 BNSS, that is 438 CRPC, is filed by the petitioner, namely so and so, in connection with South Vidhannagar 50S case number so and so under sections. This includes 302 IPC, etc.
Yes.
CD is produced, LCR is produced. Additional PP North has conceded to the submission of the learned advocate that neither any bail application under 482 is pending before the Honorable Court, nor such prayer has been rejected by the Honorable Court in respect of this petitioner.
Mhm.
Learned advocate for petitioner has submitted that in this case, petitioner, who is a responsible government official, working as a block development officer, has been falsely implicated with motivated interest, although he is in no way connected with the alleged crime. The learned advocate has submitted that on the alleged date of incident, he was at his workplace, situated in Jalpaiguri district, far away from the alleged place of incident, and moreover, he was attending his duties as the PDO. It is argued that the police did not interrogate him nor attempted to apprehend him, and it is argued that he is not required to be detained in custody for the purpose of investigation of this case. It has further been contended that the petitioner, being a responsible government officer, will cooperate in the matter of investigation and has no chance of avoiding the process of law. Learned advocate has produced photocopies of a few documents reflecting presence of the petitioner at Jalpaiguri at the material time. It has been argued that he was not present at the place of occurrence. We have found out that he actually took a flight that evening. Learned advocate it is also highlighted that the detention of the petitioner will bring adverse impact on his service career, and for those reasons, the learned advocate has prayed for allowing the prayer for anticipatory bail. Learned special PP, on the other hand, has opposed the bail prayer by submitting there is sufficient material in the CD reflecting involvement of the petitioner, who is an influential person. It has been submitted that the accused himself was involved in assaulting the victim, and after commission of the crime, he smoothly went to his place of work by taking a flight. It is submitted that a couple of persons have been arrested, and for further investigation, the prayer for anticipatory bail should be rejected. Heard both sides and peruse the case record. Also peruse the CD, which is voluminous in size. Serious allegations have been leveled against the petitioner, and the investigation. Serious allegations have been leveled against the petitioner. An investigation has progressed to a great extent. A few accused persons have been arrested and materials have been collected in the CD. Yet the police neither arrested the petitioner, who is a responsible government officer as submitted by his advocate, nor there was any attempt to apprehend him. And from this, it may be observed that for the purpose of investigation, custodial detention of the petitioner, who is a member of the WPCS, would not be necessary. It was speculative and contrary to what the prosecutor has actually submitted. After careful scrutiny of the materials on record, it is found that the government officer is attending his office, and it may therefore be observed that if anticipatory bail is granted at this stage of investigation, the process of investigation is not likely to suffer any detrimental impact. Was the second finding, which is incorrect. Therefore, upon consideration of the materials produced before the court, it is opined that the prayer for anticipatory bail may be allowed, subject to stringent conditions. Accordingly, in the event of arrest, petitioners may be released on bail upon furnishing bond of 50,000, etc. Please have then 4 lines below that. If released on anticipatory bail, the petitioner shall meet the IO twice a week till 31st of January.
That's all.
And now the direction. Petitioner shall appear before the learned court below for regular bail within 3 weeks. Return the LD. Now please have the second order. Page 46, annexure P5. The 29th of November, CR is put up today. Accused is surrendered before the court. So he actually goes voluntarily.
Last line says he will appear and apply for regular bail.
I bow down. I bow
He
down.
mentioned.
I bow down.
That's why he mentioned that surrendered today, taken into custody.
That's right.
Then it is there heard on prayer for bail on the basis of the order. Then accused has surrendered. Then he was directed to.
Copy of the order is on meticulously peruse the case record. It is axiomatic that the session judge has been pleased to grant anticipatory bail. Accused has surrendered. Accordingly, in view, the accused person is released on bail. So this happens 3 days later on 29. I, as the state, file a petition before the Honorable High Court, which begins at page 52. And please have my prayer at the foot of page 56.
Yes.
Paragraph 16. In the premises, it is humbly prayed that your lordships may be graciously pleased to allow this petition and be further pleased to set aside order dated 26th November. This is the anticipatory bail order. Please turn over the page. Third line. And order dated 29th November. This is the regular bail order. Now, because what happens is this. When I move this petition, we register the Honorable Court in order to implement his Lordship, the Chief Justice, his roster. That anticipatory bails and cancellations, etc., are covered by Lordship, Mr. Justice Jai N. Gupta's roster. Regular bail and cancellations and modifications are covered by Justice Ghosh's bench. The registry takes a decision to place it before Justice Ghosh. Not a situation as I don't go and I do it. When this issue of roster is raised, please have because the judgment of your lordships in Puran versus Ramvilas, this issue is actually settled. Then when I seek to challenge a regular bail, Because today, when I challenge this order, he is on regular bail. That anticipatory bail has
Go
merged
ahead.
into the regular bail order. Please have with me Puran versus Ramvilas, just 2 paragraphs. Paragraph 10 and 11. This is your lordship's judgment with reference to the jurisdiction to challenge a bail order where it is not on the basis of change of circumstances, but which is what Mr. Rodgi was saying, but on the basis that the discretion that was exercised originally was wrong. Please have para 10.
Yes.
Mr. Lalit next submitted that once bail has been granted, it should not be cancelled unless there is evidence that the conditions of bail are being infringed. In support of this submission, he relies upon the authority in the case of Daulat Ram. In this case, it has been held that the rejection of bail in a non-bailable case at the initial stage and the cancellation of bail already granted have to be considered and dealt with on different bases. It has been held that very cogent and overwhelming circumstances are necessary for an order directing the cancellation of
Last
bail.
5 lines are, I think, read, but one such ground.
And most of guys, and then please see para 11, where Gurcharan Singh is cited, and please see the extract of Gurcharan Singh. If, however, a court of session had admitted an accused person to bail, the state has 2 options. It may move the sessions judge if certain new circumstances have arisen which were not earlier known to the state and necessarily therefore to that court. Please see the next line. The state may as well approach the High Court, being the Superior Court, under Section 439(2) to commit the accused to custody. This is the jurisdiction that lies with Justice Ghosh's bench of 439. Please have that roster, Milal, which is part of that petition, and your lordships will just verify that. Page 88 of the petition. This is 439, precisely the jurisdiction with Justice Ghosh. So the question of when a man has been actually admitted to regular bail, if I have to challenge that and put him back into custody, the Honorable High Court can exercise only the power under 439(2) as it was then. The equivalent now being 483(3). There is nothing wrong as far as the roster is concerned. And it is in this context, now please have the impugned order, what was read out. The learned judge says, there is an anticipatory bail order, there's a regular bail order. You are saying before me, I don't have the roster. Why? Because there's an anticipatory bail order. When you go to the anticipatory bail court, Justice Sengupta, you may say, no, there's a regular order. So you can't decide it. This is precisely the point. Please have that. Page 15. Page 15. The plea of the accused opposite party that this court, that is Justice Ghosh's court, is without any authority to adjudicate the present case, which is on the issue relating to anticipatory bail. I hold that a criminal case within its ambit encompasses series of events and there may be a change of circumstances. Change of circumstances, you've got regular bail. So today which is being challenged is the regular bail that has been granted. Anticipatory bail was initially granted to the accused. It is settled proposition that anticipatory bail ends with either the accused being arrested or the bail being granted when the accused appears before the court. This is the change. Now please see 4 lines below that. The accused opposite party could have taken a similar plea before the coordinate bench also, which is having the roster and determination for deciding cases under 482, that's 438, anticipatory bail, that the accused has been granted bail by the ACJM Bidhannagar and the authority of a court deciding the anticipatory bail has been exhausted. It would be for the court having jurisdiction to decide 439, 483, which will have the authority. Having considered that the order of anticipatory bail terminated with the petitioner surrendering before the ACJM Bidhannagar, I am of the opinion that this court is the proper court to decide the issue relating to cancellation of bail of the accused opposite party, and the application for cancellation of bail being referred to this court is in the right perspective. My submission is this. This is not a usurpation of jurisdiction. This is not a situation where the learned judge did not have anything to do with the law in terms of the roster. So as far as the roster issue is concerned, it is precisely that. It is a hyper-technicality of a desperate petitioner to get out of the facts which stare at us in the eye. That you use your official vehicle, you come to this particular jewelry shop, you come in broad daylight under CCTV footage with that impunity, and you are able to pick up 2 people, take them away, and soon thereafter, one of them is left in an injured condition who has made a statement and the other is dead. And today, because I, as the state, have nothing else to do except plead with the lordships to say whether he is granted ultimately the benefit of the regular bail or not. What happens to the matter?
But one fact is there, this expiry is 31st of October.
Please, 5 persons got arrested. I am not
But somewhere in that order it was there.
that I am not arrested in.
Yes.
That's right.
He was attending the office and he never arrested.
So, because what happened?
11/11 when he got the.
I bow down. What happens is that 31st October, as your lordship notices, is the FIR.
Right.
A period of about 3.5 weeks has elapsed.
Hmm.
The month of November,
Yes.
when anticipatory bail of 26 November happens.
Okay.
So no doubt he is not arrested on day one or soon thereafter. The investigation proceeds in a manner that says, I know that there is a person who's a central figure in this. There are 4 or 5 other persons. We have arrested those 5 persons. We have disclosure statements from them. Eyewitness testimony is recorded, 164 statements done. And then when I am buttressed with all this material, he now moves in anticipatory bail because he realizes that the string by which he was
No, the
using it.
CCTV footage was very much
I
available
bow
on the
down.
first day.
I bow down. That CCTV footage with reference to picking this manner. The question of actually murder, the injured, etc., all of those were subsequent steps that took place.
You
Which-
gave this statement when?
But I'll place that straight away. I have an entire set of the facts.
The FIR itself, he has made this allegation.
The allegation was that he came and he picked up us. Please have the FIR note. After that, I'll give. Please have this. We have the compilation of the relevant documents being a copy.
Yes.
So the first thing that happens is I'll show that document. Show me what.
Yes.
7th November, a co-accused is arrested. From his phone, a video is found. That video shows an assault which has been led by this petitioner. So 7th of November 2025 is when this entire narrative begins. After that, look, dates. Page 3 look, is the injured witness. The first, this is recorded on 7th of November. And please have page 2, foot of the page, where he talks about 500 to 600 grams of jewelry. And then please turn over the page at page 7, about 6 lines from the top. On 29th of August 25, petitioner and 3-4 persons going to my house asked about the ornament. They beat me and my wife and my daughter badly. After that day, they brought me to the house of the petitioner at Newtown, beat me badly. I admitted about the theft and told that I had given the ornaments to Swapan. That's the deceased. They told me to take them to the shop of Swapan. I told them shop was closed. Petitioner, seeing the phone number written on the board outside the shop, phoned him and took the details of Aadhaar, thereby linking it with Aadhaar, found out the house of Swapan and took me there. However, Swapan in the house, they returned with me to the house of the petitioner at Newtown. They let me go and said, remain in your house, come when we shall call you. After that, on 28th of October, last petitioner, by sending men to my house, brought me to his house at Newtown at 12:30. I found that after that, petitioner had some other persons brought Swapan to the house of Prashanta Burman at Newtown. After that, they and Swapan in a room on ground floor and beat both of us badly. Amongst them, Prashanta and some of his followers were there. All of them hit us with bamboo, lathis, waist belt, shoes at about 5:30. Swapan admitted that he had taken the gold and he sold the same. Swapan told Prashanta Burman that on the next day he would give the same at about 6 p.m. Petitioner told me to go to my house. When at the time of going to my house, I found that Swapan was lying on the ground senseless. I came to my house and after 2 days, I heard that Swapan had been murdered. Will you say anything else, Monisha? The aspect that the gold was stolen, something that he knew 2 months earlier. He found this man, beat him up earlier, then took him on the date of the incident, an injured eyewitness present at the spot. Now please have with us the other persons as
This is
well.
164 of that.
This is 164 statement.
183.
That's right. 164 statements. So I ask myself, in a measure of,
Injured person.
he is the injured eyewitness. In a measure of about 24 days, the investigation has progressed in a certain logical sequence, which to the investigator, Manoj, was logical.
Yes.
So look, as far as the investigated material is concerned, my submission for Lordship's consideration is that over a period of 22 days, we record statements of multiple eyewitnesses, the injured eyewitness, physical evidence, the mobile phone of the co-accused, which results in the discovery of the fact that there is a video which has been taken showing the petitioner leading that assault.
No, that phone is off.
The phone is of the co-accused, arrested co-accused. When the accused got arrested, from his custody, we got his phone. That phone had a video. And that video shows that the petitioner was there leading that assault. Now, in a matter of 22 days, maybe somebody else says that he is the person from whom.
What for the accused was recording all this?
Look, sometimes I guess you try and give yourself medals and certificates, you record your conquests in life. This is actually, that's the level of impunity with which this crime has been committed. It is something which actually shocks the conscience that the man actually comes in his government vehicle to this shop in order to make this abduction. Because your lordships are right. It is possible that some other investigating officer in some other scenario may have commenced the investigation through this petitioner's leg, saying this is one of the persons who's been identified. But the investigating officer has proceeded in a way which is equally reasonable to say, I have 5 other accused persons, I have arrested them, I have collected investigation, he's a government servant, hence I must be careful, a little bit extra careful when I make that allegation. And in that context, the fact that he was not arrested for 24 days is not something which acts as a reason to grant him anticipatory bail to say you will never be arrested.
Let him.
And the date of moving the anticipatory bail appears to be 10th of November. So it's
11th of
11th of November. So it's within about 10-12 days
Yes.
of the incident.
Interim was granted or not?
Interim, I'll just check.
Yes,
I'm
anything.
on that.
Well, signed for the complaint, my lords. The deceased was my sister's husband, my lords. Just 4-5 submissions, my lord. In fact, this man is very notorious. In fact, his appointment as a BDO himself was a matter of challenge before the High Court, my lords. So I'm just telling, my lords, his history, my lords. He moves around in his government vehicle, my lords, threatening people, my lords. On broad daylight, he picks up the, my lords, deceased.
That's the story
Yes.
of this case.
Yes, my lords. And CCTV footage is there. There are statements of injured. Lastly, my lords, new my lords, he is threatening my lords. My sister, she has 2 small children. He is threatening my lords. When he was outside, my lords, in fact, they were running around, my lords. That's why I had to come and pursue this case, my lords. We informed the police also, my
Your
lords.
sister is
Deceased wife, my lords.
deceased wife is not the complainant.
No,
Complainant
but
is
yes.
something else.
So my I am the brother of the my sister is the wife of the deceased, my lords. So I have to come and pursue before this honorable court. I was not a party before the
Now you say he is threatening the victim's family.
victim's family. Yes, my lords. And she is a young widow, my lords, with 2 small children, my lords. And she had to complain to the police.
You lodge the complaint for that?
My lord, this will be placed on record because my lord.
Will is not there now.
I'm sorry, man.
Oh, will is not there now. We have to decide it. We have
Very
heard
good.
the
Just
argument.
get that. Just
Have you filed any complaint with the police authorities that he is threatening or something else?
give it to the street.
Yes, we
Yes.
have informed the.
My lord, but my sister, they didn't inform the police, my lord. They have informed the police, my lord.
You don't know.
4th of December.
4th of December.
Not on the court. As per instructions, 8th of December,
4th was the threat.
we had diarized it in our
Both we had got a threat, then there was a letter, my lords.
the allegation was that he received a missed phone call from
This one number.
4th December 25 from a particular phone number. And when he rang back to the number, he has been threatened by the caller. That portion is written in Bangla, so I will not have the ability.
I can read it out in English.
Just a minute, let it complete.
And we then advised them to inform the matter to local police. He said he will not be able to continue the legal fight against the petitioner. He has been found trembling over the phone call. He has been assured to inform the matter to local police station. He will think again. He says he's afraid to.
Some complaint is there.
Complaint is there, dated 4, diarized by us on the 8th
On 4th of
December.
December.
All right.
I'll just say one quick point.
Yes.
Just to. The High Court, my learned friend's argument is wholly incorrect in law in saying that it is a regular bail that is granted. Please have the wordings of section old 438
and the new 482. The bail can
Come to the order. Come to the order whereby the bail is granted.
Yes, that's what the order holds, my lords.
Page 45.
Page 45. No, I'm on, my learned friend's argument is
5 and 6.
that once
44.
bail is granted, it is a regular bail.
No, we are not on that.
No,
Page 45 bottom.
Yes.
Here, brother.
accordingly, in the event of arrest, my lords.
No, that is there.
Yes,
If released on so and so. Thereafter it says attend the court.
it has to be regular bail. That's what I'm saying. Please have the wordings of 482. The lordships are referring to the wording of regular
Two
bail.
part, na. Thereafter,
Petitioner shall
and the
appear
petitioner shall appear before the
learned court.
court for regular bail within 3 weeks.
Yes,
So that
why?
means it was only for 3 weeks.
No, so the reason is,
Then next,
my lords,
page 46.
petitioner has prayed, has appeared before so and so.
Not before that, accused so and so.
Santa Burman is
I have to
surrendered
surrender.
before this. He is taken into.
I have to surrender. That's my
He is taken
argument.
into
Yes.
jail. A petition is filed accused.
I have to. If I am not arrested, there is no bail that can be granted. My lords, bail, as your lordships are aware,
But there, before that, it is there anticipatory part. Just 7-8 lines above the bottom, page 44. Prayer for anticipatory bail may be allowed subject to screening.
Yes.
Accordingly,
yes, my lords,
in
accordingly,
the event of arrest, the
Yes.
person namely so and so may be released on furnishing bond so and so, subject to the arresting officer,
yes,
right?
yes,
This is arresting officer. If he does it, matter of relation.
yes.
You are not
And-
required to go to the court.
And
No,
if,
you are not required to go to the court if this is done.
no, there are two ways, my lords, anticipating bail. Either the arresting officer upon arrest can release me on bail, or upon my surrender, because I'm in the custody of the court as an arrest, I can be released on bail.
No, but
Both-
did
both
the
ways.
arresting officer arrest you? You had
No,
surrendered before
both, my
him?
lords, both.
No. There are two separate things.
Yes, for both, my lords. I have to be under arrest for an order of anticipatory bail to kick in, my lords. I have to be in custody. I can't be granted a cut. Please have the opening lines of 482 for a moment. The section.
Yeah.
And compare it to the section which grants bail, the old 437, now it is 480, because we are grappling between two bare access. Please have 482, I'll read. It specifically provides 482 DNSS. 482. Says, my lords, when any person has reason to believe that he may be arrested, an accusation of having committed a non-bailable offence, he may apply to the High Court of Sessions for a direction under this section. And that court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail.
Right.
I have to be arrested for the order of bail to anticipatory bail to
That's
kick in.
right. That's
Now,
right.
now please see, my lord, I'm just on the board. Please see 480. 480, which is the old 437, my lords, which is the power to grant bail.
Right.
When any person accused of or suspected of the commission of any bailable offence is arrested, already arrested, or detained without warrant by an officer in charge of a police station, or appears or is brought to a court, before a court other than the High Court, he may be released on bail. The nature is, my lords, the thing is that without bail is only for custody. You can be in police custody, you can be in judicial custody, or you can be in private custody. Bail is private custody. I release you in favor of the bail bond of those who are giving the sureties that are there. You are in private custody thereafter. For an order to be effective under 482, under 5, which is the old 438, it is necessary, therefore, your lordships, when your lordships also pass the order, anticipatory bail, petitioner will surrender and obtain bail. That is not a regular bail in the sense it is not like the 437 bail where a person has been arrested only. That is necessary to give effect to 482, that only upon arrest do I go into that bail I'll be granted. That is the nature of it. So it remains anticipatory. Merely because I have secured bail pursuant to this 482 doesn't mean that I have got regular bail in the sense of regular bail where a person is arrested and is being detained by the police and thereafter he applies to be released on bail. So let's for a moment let there be no confusion with respect, my lords, about the nature of bail. This is a consequential order of an anticipatory bail that is released. That is the part. So it should have gone before the other court, my lords, which was dealing with anticipatory bail.
Right.
That is one.
Right.
In my petition also, I have annexed my entire attendance sheet.
That
It is-
is,
Not that I was absconding,
no, it's
not that any efforts were
we
made.
have already asked.
Yes, nothing. Suddenly, my lords, the High Court now takes into account all these things before it, the material, all the entire material in the cancellation. High Court can say that, look, under 302, it is very difficult to grant anticipatory bail. We don't think it should have been granted. But in material analysis of all the material case diary in detail by the High Court to cancel, when there is a challenge to grant of bail, my lords, then the High Court cannot look into all this material. It can say, no, this bail has been wrongly granted, or remit it back to the original court, say that please look at all this material that is there and come to a decision. Either of the two ways. If it is for a cancellation under 439,
Sent back only then.
it could be sent back that, look, you have wrongly granted
High
it.
Court has considered and cancelled it.
Yes, that's what, but the original court didn't consider it. Original court didn't consider it. This is a challenge to a grant of bail, not a cancellation when I have abused my bail, which is the 439.
That he has read that.
So, my lords, when we come in appeal before your lordships, my lords, only the material that is there before the court that will be there. Whatever you have done apart from that cannot be placed before that court, the appellate court, and say that you please go into all these questions and now decide it. If it could have said, my lords, I don't stand in the way, 302, very difficult. I think the prima facie you're named in the FIR, we reject. This should have been, we cancel the bill. But to come to a conclusion that there is this statement, there is that statement, this material against you, that material against you, in a challenge to a grant of bail, my lords, in my respectful submission, it will not be available before the higher court, which is dealing with that. That is the part. Thirdly, my lords, is an alternate submission. Were your lordship to hold in favor of the, reject my present petition, my lords, then please hold at my request, my lords, that the observations of the High Court may not come as far as my regular bail in the sense of 437, etc. When I move for regular bail, maybe. I have to, I'm clarifying this part, my lords, out of abundant precaution, my lords, this part.
There's one sentence on the material. These statements are part of my case diary. The learned session judge says I have perused the entire case diary. All this material was there. It obviously did not consider it. That's different from saying it was not there before. It was definitely.
I'll let my learned friend have the last word. There's no.
I'm obliged to my learned friend as well.
That's all.
So that's, I said, I'll let my learned.
We are obliged now, you have come.
So we don't agree with this.
Gotcha.
How much time we will surrender then?
2 weeks, there's 26 January, etc. I surrender it in 2 weeks.
You will be on duty on 26th.
I'm still on duty. I'm still on
26th January or
on duty. I'm going every day. Grant me 2 weeks, I'll apply for regular days.
There's some time which is already left, but I leave it entirely to your lord.
2 weeks, not.
Or 10 days.
You can't be allowed to attend the office now.
10 days. 10 days I'll. I mean,
Can't be allowed to attend the office.
I won't go to office, no, 10 days, your lordship.
What about?
Lordship, I fix the time.
You surrender immediately.
1 week, I'll surrender.
Surrender within 2-3 days.
5 Fridays.
I'm
The
obliged.
difficulty is not Friday, if he surrenders by the time then 26th, the courts are closed, etc. Therefore, I was asking for a time beyond 26th.
But we'll also take some time with the investigation.
So you may surrender tomorrow itself. What's the problem?
Yes, of course. Just-
Then 26 January is far off.
They just give me till next Monday, Tuesday, no, I'll surrender. No
No,
difficulty.
no, Fridays.
I'm obliged.
By Friday.
An uninfluenced part can come, if I apply for that. I'll
So
surrender.
there are two things. If you want detailed order, we can give you detailed order.
No, I don't want a detailed order.
All those three,
Detailed-
all that, everything we can. give.
Detailed orders are always dangerous, my lords, in interlocutory matters.
Because roster issue and all that, we can deal with that. But,
It was not our
No.
endeavor to cast any aspersion.
Nothing.
On the judge.
Legal-
It's an argument. No, it was an argument.
Yes, it was an argument.
Creating limit counsel for the parties. We do not find any cases made out of interference with the order to be. Stop as requested, if we grant particular time till February 20, no, sorry, January 23, to surrender before the court. Court or jail, very
Concerned court.
before the surrender, before the concerned court. And thereafter can apply for regular.
Subject obviously nuts to the investigating officer moving appropriate application.
Yes,
for-
yes.
That has to be there. So you can make it,
Just to add that any such prayer shall be considered by the court concerned without being influenced by any observation in the orders already passed and after due notice to the prosecuting.
Lordship.
if Lordship will say, including with the ability to seek custody remand if.
That is always there, it
That
is open.
Your Lordships are saying apply for regular bail, I don't want it to be
Alright.
said.
They also clarify that in case the investigating agency seeks remand of the petitioner, and they may move appropriate.
I'm most-
application.
I'm okay.
So the irony will be if it goes back to the same magistrate who released me on anticipatory, you know, puts me back in custody.
It is
No,
better,
it's-
he is aware of everything.
He will say session court.
Yes.
He offers.
I'm-
Wait for me.
30. 30 is what will be
Wait, please, my lord.